Okay, excellent. Welcome everyone, and thank you very much for joining our conversation on data privacy. My name is Andre Palmer, and I'm the Head of Research and Engagement here at Symptai Consulting. And I'm really happy to be facilitating this conversation today. We're going to be talking about maximizing value and minimizing risk, and it's really a conversation around the upside of data privacy regulations. I am particularly excited to have Grace Lindo and Andrew Nooks in this conversation, as I cannot think of two more experienced and qualified and passionate professionals within this space. And I'll introduce them a little bit and talk a little bit more about why they are the experts and the voices to listen to during this conversation. Throughout the webinar, you can ask questions. You can type your questions in the comment and question sections, and towards the end, we will give you an opportunity to hear responses to some of those questions. If we're not able to get to all of them, we will certainly reach out to you afterwards with responses. So why are we having this conversation today? We have been talking a lot about data privacy lately, and that is because we realize just how important it is to organizations. We're living in what a lot of people will call the data economy, where data is the new oil or gold, depending on what you trade in these days. And that is why companies like Facebook and Amazon and Google really have been able to generate billions of dollars in revenue just from using the commodity of data. The sad reality, though, is that the collection and use of data is sometimes misused by many companies, and that is why we're seeing an increase in regulations to protect the privacy of data subjects. So data privacy regulations can be seen or is viewed by many as a burden that carries with it significant costs and a few tangible benefits. This has been compounded historically by the aim of gathering as much data as possible, because organizations tend to think that more is more, and the more data you collect, then the better it is for you. However, we've seen in a number of cases that is not always necessarily true. So given the number of high-profile data breaches in the past decade, from the likes of Sony PlayStation Network in 2011 to LinkedIn in 2016, consumers have become increasingly, or they are becoming increasingly aware of how valuable their data can be and the potential dangers of any kind of data being leaked. So with the growing number of data breaches, consumers are now wary about who is collecting their data, where is it being stored, how is it being stored, who has access to it, how is it being used, how can they get access to it in the event that they want to, and how will it be destroyed when you deem it is no longer necessary. So for a lot of companies, though, there are a lot of pitfalls when it comes to complying with data privacy regulations. And a part of the conversation we want to have today is really just to bring your awareness to the rights of the data subjects. So what are they entitled to under the law? But also, by implementing compliance or implementing data privacy regulations, how your companies and different organizations can become compliant with various pieces of legislation and the benefits that these can bring to your organizations. So the first presenter is going to be Grace Lindo, and she's really going to be talking about the rights of data subjects. So let me tell you a little bit about Grace. I did say I was excited to have her on. So Grace Lindo is an experienced commercial and intellectual property lawyer. Her practice covers intellectual property, technology and technology transactions, e-commerce, trade, regulatory matters, cybersecurity, data protection, corporate governance, and mergers and acquisitions. She's a evening scholar, and she attended a very, very good school, the London School of Economics and Political Science, LSE, from which she obtained a Master's of Law in Competition, Trade, and Innovation with a focus on technology regulation. Grace has been consistently ranked as a leading trademark professional in the Caribbean by the World Trademark Review since 2014. She is a certified information privacy professional and an accreditation which is given by the IAPP, which is the International Association of Privacy Professionals, and they're the foremost accreditation body on data protection and privacy worldwide. Grace was also Jamaica's only ICANN fellow over the last 5 years, which has been an honor for her, and she has been able to contribute to global internet and Technology Policy through the extensive ICANN network. She sits on the Legislation and Regulations Committee of the Jamaica Chamber of Commerce, as well as the Commercial Committee of the Jamaica Bar Association, and is a director of Edufocal Jamaica Limited. Interesting to note too is that since the tabling of the Data Protection Bill in 2017 in Jamaica, Grace has acted as counsel for the Jamaica Computer Society and the Jamaica Information Technology Services Association in their presentation to the Joint Select Committee reviewing the bill in the Jamaican Parliament. Grace will speak for a few minutes about the rights of data subjects based on applicable pieces of legislation and board responsibility in ensuring that these rights are being protected. Grace, it's over to you.
Right. Over to me. Thank you, Andre. Thank you very much. And good morning to our attendees and panelists, fellow panelists, and of course the Symptai team. Thank you for having me. It's always a pleasure doing things with Symptai, working on projects with Symptai. Well, so this morning we're talking about data protection, data privacy specifically. And I wanted to, well, you have asked me to talk about the rights of the data subject, which is very good that we're zooming in on a particular aspect of the law. This is a very large piece of legislation. And so there is an attempt sometimes to cover all aspects, but it's very good that we're focusing particularly on the rights of the data subject, which change from time to time depending on the industry that you're in, and that's equipped there for the persons who may be from a particular industry and are looking at the law and data privacy from a particular lens, from a particular scope. So the rights of the data subject are pretty new rights for us here in Jamaica. We never ever had before extensive rights given in respect of data, information that belongs to someone, and I use the word belongs in quotes because there's a lot of academic material out there about whether we actually own our information, which is why we have this piece of legislation in the first place. But it's a really new type of law. You know, we've had the Electronic Transactions Act, which speaks to e-commerce really, and that did speak to privacy policies, but that was really in respect of privacy online and credit card information and doing business online, transacting online. It really didn't speak to information. But as you said, Andre, information is no oil or gold. It is currency. We've seen it in, let's go there, elections. We've seen it in commerce. We're seeing social media companies rise because of data. So, you know, people are making money out of our data, and it only stands to reason that we should have rights if other people are using this as capital. And so when we think about the rights of the data subject, I have to start with what is now considered the right to informational privacy in Jamaica. And I start there because as of now, that's really the most concrete form of right that we have. Our Data Protection Act has been passed, but it is still to come in force. It hasn't been signed by the Governor General, and even then it will have a leeway, a time grace period before it really comes into force. So we're really in a get ready stage. So in terms of the right to informational privacy, we now have that right enshrined, you know, or implied for us by virtue of the NIDS case, which is what we like to call the case which was taken to the Constitutional Court. And that, of course, surrounded our identity mechanism, which is being put in place, and it's proposed still to be put in place. And what the court said is that every Jamaican, every citizen has a right to have their information, their biometrics, their information about them kept private. That right to privacy is a constitutional right. It's very important to know this because what that means is even though without a Data Protection Act, there are rights which every Jamaican has, every customer of yours has in respect of their information. And it's time to start respecting those rights. It's time to start putting in place some of the mechanisms, which I'm sure Andrew will speak about after me, because it doesn't mean that you are, you know, in a free-for-all stage just because we don't have a Data Protection Act. There are existing rights and compliance starts now. So who is a data subject if we are to look at the act itself? The data subject is any person who is named or otherwise identifiable and who is a subject of personal data. And let's just stick a pin here. You know, lots of us deal with data for clients, for customers, and we think, well, you know, this is someone who have put a name beside an actual line in a spreadsheet, for instance. But if I don't do that, if I don't use a person's name, I'm not dealing with personal data, and that's totally incorrect. Where someone is identifiable, it could be through their IP address, so everybody has one. It could be through their account number if you're a bank. It could be through your employee number if you anonymize the employees or try to anonymize the employees' identification, but you only have 60 employees or 600 or 6,000, and you know who employee 5,551 is. That's identifiable, and that means you have personal information on the individual. We have to broaden our scope as to what we think is personal. People try to get around it by just saying, let's just use this identifier here to say who this is, but that's still personal information. And the other thing to remember is data protection and data privacy and laws in the area don't only apply to electronic storage. So, I have a little filing cabinet behind me here, which you'll see. If you keep your files in something like that, and you don't put them online because you're afraid of coming within the boundaries of the Data Protection Act, I have news for you, you're still within the boundaries. And our act is very explicit in respect to that. No matter how you store the personal data, digitally or otherwise, you're bound by the data privacy rules and the upcoming Data Protection Act. It's pretty broad in that regard. So anything, as I said, which makes a person identifiable is something which is going to cause you to come within the boundaries of the act. Now, why do we use the term identifiable? It's because, and the techies will tell you more, I'm not a techie, I'm a lawyer, but the techies will tell you that triangulation now is very easy to do. It's very easy for you to use different data access points and different data sets to triangulate and determine who is who. We all hear of the stories, we have the anecdotal evidence of persons who get documents or get communications in respect of their medical diagnosis or in respect of something regarding them without they themselves having known that, hey, this is happening to me. And it's really because, the persons who process our data can come up with a background story about us and know things about us before we even know them ourselves. Stick up in here, but this is why sometimes when you think you have been thinking about something and you see the ad on Instagram suddenly pop up in your feed, you wonder, well, how did they know that I'm thinking about this? Because really, there are other things about you which indicate that this is where your mindset is. And so they're going to push that ad into your stream. So we're talking about things like that. And we're seeing lots more Jamaicans getting into triangulation and getting into using data to make decisions and to really create money, to create capital. Now, Jamaica has expanded the definition of who is a data subject. For several countries, it is limited to the natural persons, people like you and me who have flesh, not companies. So we're not talking about information about companies. But Jamaica has said that the Data Protection Act also extends to people who have been deceased for 30 years. I am still to look for the Hansard Parliament deliberations, which led to such a decision. I'm not sure if I necessarily agree, but this is the law. So it means that if you're a funeral home and you think you don't have lots of data about people, you're captured by the Data Protection Act and they have data privacy rights too, right? So it's a pretty extensive piece of legislation when you think about it. Now, data is anything that you have now or anything that you may come into possession of at a later date. So you may be able to identify someone not only based on what you have now, but based on information that you may have later down the road. And so you have to be very conscious of what is really personal data versus what is not personal data. One exemption, of course, one big exemption is domestic data or data used for domestic purposes. So if you're using data, for instance, at home and you have your kids' documents and you have written down your immunization records or something, that's not necessarily personal data, but you have to be very conscious of when that crosses the line. Maybe you have this personal information and you're using it now to create an app and you're now extending that application to family members and to outsiders. Is that really still domestic? There's some, case law and there's some information coming out and experiences coming out of the EU as to when does a domestic purpose cross over into public. For instance, if you have a Facebook page or some sort of, mailing list, which is just, again, family members or a few people, when that goes to 500 and you don't become an influencer, do you then say that the information you collect here is more than for domestic purposes, it is for business purposes? And so, you become again within the boundaries of that. Those are the little things that you need to be a little bit conscious about. Now, the rights of the data subject is perhaps the crux of, is the crux of what I'm presenting on this morning. And there are various rights which accrue to various types of data subjects. And if eventually, my hope is that when we discuss data privacy in Jamaica, we'll go and look at it from various subsets. So it's important for us to start thinking about it from the employment perspective. HR professionals need to have a different perspective of how data privacy works and how the data protection applies to them, because employees may have private information, but they may have what we call sensitive information, which requires enhanced data protection regulations. So you need to store it in a certain way, differently from how you store other types of information regarding people. And sensitive information includes information on people's race, origin, sexual orientation, trade unions. Again, for HR professionals, this will be very important. It includes things like political opinions and whether they have committed an offense before. That's very sensitive data. And of course, medical information, health information, that's very sensitive data. So you have different levels of protection which will be required for different types of data. And as I said, I think people like HR professionals, health professionals, people who are going into telemedicine, for instance, will need to start breaking out aspects of our regulations, aspects of our law in respect of data privacy and data protection, and seeing how it applies to them separate and apart from the general application. And I'm sure we'll see more application. When we speak of applications, we'll see more software, and we'll see more toolkits, we'll see more assessment tools which are being developed for those particular industries, because it's very important for us to know what applies to us and what doesn't apply to us. If it applies to our sector, for instance, the financial sector may have very specific rules in respect of how they deal with data, separate and apart even from the Data Protection Act. We need to be very sensitive to that, pun intended, sensitive data. Right, so Data Protection Act, as I said, it is now passed. We're waiting on the GG to sign it, the Governor General to sign it into law, and then there will be a grace period of, I think, 2 years for us to fully implement it, all aspects of it. It applies to us in Jamaica, of course. It also applies to people who are processing the data of Jamaicans overseas. And that's a late addition to the draft bill, which was done. I'm curious as to see how that will be enforced, but it is there. And it may mean more, if you're in the tech business, it may mean more business for you, because it will mean that, overseas companies will need to be compliant, even if they're keeping their data centers, in another jurisdiction. They will need to be compliant once you're touching on the data of Jamaican citizens. And that's a big deal, I think. I think looking at it from a consumer protection perspective, it is the right way to go, but compliance will become, something to watch. So what do you get when you become a data subject? What are your rights? Now, the principal right as a data subject, as an individual with personal data, is the right to have access to your data. The right to know what people are saying about you in respect of your, not necessarily opinions, but in respect of what information they have about you. So if it is your bank, or perhaps if it is, a utilities company, they have a right to know what information they have on you in respect of perhaps usage, your geographic information, if they have biometrics, what they hold in respect of you. That's something that they will require to be told free of cost if an inquiry is made. And just to stick up in, they'll be required to tell you free of cost if they have information on you and the type of information. When we go into the specific type of specific details of the information, there will be a cost which will be levied on you, and that's to be prescribed. It's not something that you as a company will have the discretion to determine. It will be put out in the regulations to the Act, which we expect to come into force very shortly. So you'll also, in brief, you will thereafter, after the Act comes into force, have a duty to tell data subjects, to tell people, your customers who come to you, what information you hold on them. And that's I think, a big step for Jamaican companies. That's a whole, for some companies, you'll now require either automation or a whole department to deal with that, because that's an entire new level of compliance which will be required. The data subject also has a right to consent to their data being used. We all get messages from time to time, from text messages, I freely say this, from time to time, from sources that we wonder, how did you get my number to send me a text message? We'll have to take a step back and think about things like that, and whether it is appropriate for us to send those types of messages. But the data subject, as a general rule, has the right to consent to the processing, we call it, of your data. And consent is very specific. It has to be freely given. It has to be unequivocal. And you should be able to withdraw your consent, which is very important. How does this play out for you in determining your products and structuring your products, especially as everybody's online, everybody has an application? It means that you have to start doing what people in the tech world will call privacy by design. You have to start doing more opt-out notifications, which if you look on any website which is out of the EU, or most websites now have a little bar at the bottom, which can be annoying, but it's required by law, which says you must accept cookies. And of course, you know, cookies are trackers which enter your computer. Techies can tell you, but it allows you to process and for your computer to move much faster if you've been on this website before, if you've used the website before. But things like that, privacy by design, will become much more applicable in how you do your applications, whether it's your banking application, whether it's your utilities payments application. You would have to make sure that you structure it in such a way that people don't just click yes so that they go to the next page. It must be informed. You have to have a method of knowing that people have read it, or you gave them the advantage of reading it as much as possible. So in terms of designing products, it will become a lot more applicable for you no matter what industry you are in. And certainly for direct marketing, our parliament has taken the position that consent is needed for direct marketing, specific consent. Not all jurisdictions have this, and this is a late amendment to our law that was made. But direct marketing, of course, as you know, is the use of email lists for you to be told of different products and services from time to time. It is something which can be an invasion of privacy, because what it means is that you are, you're unable to unsubscribe sometimes from these email lists. And so the thought process behind it is that you should be able to consent or opt out at the very earliest, for certain types of direct marketing. You should be able to consent, or you should consent rather, where you are being told of these, types of products and services. Now, the rights of the data subject extend to the right to ask for your records to be kept accurate. And this is a big deal. And I think compliance-wise, it'll become very, it may become very hard for companies initially to deal with, but it requires inaccuracies to be rectified as soon as possible. So if you are processing the data of a customer and the customer comes to you and says, no, you have my wrong address, you have to make sure that that is updated, because they have a right to make sure that everything in respect of them is correct and up to date, because decisions are being made of them sometimes without their knowledge. And so they have a right to make sure that at least their information is up to date and accurate in all respects. The data subject also has a right to have their information on their data being processed fairly and lawfully, to be used only for a lawful purpose, and really to be used only for the purpose for which it was collected. And this goes back again to the issues that we've been having. We've been seeing people collect data for a particular purpose, sell that data to another individual, or even change their business model in entirety and start using the same customer's data for that new business model. We'll need to change those sorts of practices, because we need to now start to think about purpose limitation. What purpose did I gather this information for? Have I used it beyond the purpose for which I gathered it? It's a change in mindset, which I think initially will be something for us to get over, but it really goes to the benefit of the consumer. You must only collect information from your customers which will be adequate to your purposes. So if you need, as a marketing company or someone that's collecting data on purchases, if you need my name and my address and perhaps the types of purchases that I have made, then you really don't need my mother's maiden name. There are certain types of information that you may not need from me in order to do what you need to do when I ask you for your particular good or your particular service. And we need to start thinking about that. So we need to start limiting, for instance, our questionnaires. I know perhaps for the financial institutions, this may be tough because they're liable under other pieces of legislation to collect as much information as possible under their KYC procedures and guidelines. But we need to start thinking, well, do I need this information from this customer, or is this just something that I additionally wanted to tick a box on, right? Only collect the information that you need, and the data subject has that right to only give information over which is really required for the purpose for which they're seeking the good or service. particular contract for goods and services. And of course, the data subject also needs to be sure that if they give you the information, it is only kept for that particular period of time for which it is required. So if you don't need the information beyond the time frame, for instance, that the service is required, then it needs to be deleted. And when we say deletion, we mean it must not be kept in another storage folder or somewhere else within the organization. It has to be deleted in its entirety. And I could go on a lot more in terms of other aspects of our new data privacy regulations, which have an impact on the rights of the data subject. But I think I'm going to wrap up right now so that we can proceed to the other aspects of our panel this morning. In summary, this is something which is it's a new era for us in Jamaica. But as we move more into becoming a digital jurisdiction in terms of doing more e-commerce, doing more business online, you will see the rise of the consumer being, also online, acting virtually and expecting certain things which are in place in the physical world to also be in place in the virtual world. And let me just give you an example of that and why we have, for instance, cookies before I go. When you go, and as persons of color, primarily of us in Jamaica, we are very sensitive to, when you go in stores or you go into an establishment and you're followed all around the establishment, because people think that I don't know, for some reason that they're there for some nefarious activity. And that's offensive, right? I mean, I have, and I won't call the names, but I have particular places that I have never stepped a foot back in for that particular reason. It's the same principle. You don't want to be followed around the internet because decisions are being made about you're being profiled on the internet by virtue of your makeup. It could be your racial makeup. It could be your financial, background. And you don't want that sort of information to follow you around and for it to have an impact on future decisions about your life. And so that's what we're getting at when we talk about data privacy. We're talking about things which will allow you to live virtually in a very free manner and will be able to allow you to do commerce and to do business without having any sort of discrimination. So you have to think about it in that light. That's it from me, Andre. Over to you.
Great, thank you so much, Grace. There's so much to unpack in this particular piece of the conversation because there are so many rights, and it means that organizations now have to think about implementing a mechanism through which these rights can be observed and through which some of the requests can be fulfilled quickly in the event that a data subject suddenly decides, all right, I want to see the information that you're holding on me. I want to see the purposes for which you're using all of this information, and I want to see the policies that you have in place to protect my information. And I think that is actually a really nice segue into the next part of the conversation with Andrew Nooks. And most of you on this call would have been familiar with Andrew. He's been in this space for over 25 years, and he is one of the most leading thought leaders when it comes to this aspect of data privacy. So I'll tell you a little bit about Andrew, and then he will talk about things that organizations can do to implement tools, systems, policies, procedures to allow for the effective management of the rights of the data subject. So Andrew is a director, Andrew Nooks is a director of efficiency and growth at Symptai Consulting and has over 25 years of experience in information systems administration, IT audit and security assessments, and IT advisory. He has a BSc in computer science and mathematics from the University of the West Indies and certifications from the industry-leading organizations such as ISACA, ITIL, PSI DSS, and BSI. Andrew is a certified information systems auditor, a certified information systems security manager, certified in risk and information systems control, certified information systems security professional, information system security professional, certified secure software lifecycle professional, payment card industry professional, payment card industry qualified security assessor, and the list goes on. Andrew, forgive me if I don't read out all of them. Andrew provides services for application security assessment, network penetration tests and vulnerability assessments, security awareness training and assessments, IT governance review and implementation, security incident response, and digital forensics. He is a member of the board of directors at eGov Jamaica Limited and Michaela Financial Services. He is also a member of the Jamaica Computer Society Special Interest Group on Information Security. Like I said, Andrew will speak for a few minutes on tools, systems, policies, and procedures that organizations can implement to ensure that the protection of the data subjects is paramount. So Andrew, over to you, and then at the end you'll bring both Andrew and Grace back in for some question and answers.
Thank you very much, Andre. Can everybody hear me? Well, I guess, Andre, can you hear me clearly?
Yes, hearing you clearly.
All right, great. Morning, everyone. Grace, thanks a lot for setting the perspective. What I want to talk about this morning is looking at maximizing value. But first, privacy, the right to be left alone or freedom from interference or intrusion. And information privacy is a right to have some control over how your personal information is being collected. And Grace did mention that this personal information has to also has different categories. The special information or sensitive information and others, even derived information. Privacy is important because of the nature of data now. You know, Andre referred to it as gold or oil. And a lot of organizations are using this data to monetize this data, and some are doing it in ways that are not as responsible as others. They're also using the data to influence outcome of governance and elections and all of that, right? And then what this does is to leave organization with a complex matrix to ensure that if they're going to use data, they have to use it responsibly. And this involves putting in the necessary controls in place. But to get to controls, you have to look at systems from the perspective of the strategy, the governance, the operations, and then finally the tools. For most organizations, when we talk about strategy, we're talking about revenue generation and monetization of information, increasing value by managing quality of data, you're looking at your customer relationship, and by so doing managing your brand and your reputation. But then the other side of it is managing the risk. So that part is monetizing. Managing the risk now comes with doing your risk assessment, understanding the data that you have and how you collect it, from collection to deletion. And then the whole business of data protection has to come front and center, not only because of legislation, but because of the harm that it can cause your organizations if you should suffer a data breach. From the governance perspective, and putting in privacy usually have two main streams. You have the governance side and the operation side. And from the governance side, you have to have a clear vision and mission. You have to identify your stakeholders. You have to have a team structure for your privacy that is consistent with your organization and the strategic outcomes that you're wishing to gain. Then you have to develop a framework for privacy, which would include policies and procedures and metrics in order to manage these, right? So that's governance in a nutshell. Then we look at the operations, and for operations, you have four main components. You assess, you protect, you sustain, and respond. So let us just look at that in a little bit more detail. From assessment, you have to come up with an assessment model, and that will be based on the framework that you have decided to adopt. Grace mentioned privacy by design, and that is building privacy into the DNA from concept to implementation and sustenance. You have to ensure that privacy is a part of the entire process. Then you have the privacy maturity model, where you go from possibly having something ad hoc to something very optimized. You also have to assess your business, and assess your business from the perspective of the data, the systems, the processes. If you're going to be collecting the information for data subjects, then you have to understand your collection point, and that starts from understanding the process. So you document your process. On top of the process would be how the data flows across the system. So you'd have to come up with your data flow diagrams. The system, we collect the system from the internet, from this system. It moves through a firewall, possibly to a database backend, and it is processed by different parties. We have to understand how that works. And all the different systems, I mentioned firewall and database systems, all the different systems in that set, right? The next thing is looking at the protection aspect. And from the protection aspect, you're looking at the data lifecycle management. I mentioned before that data lifecycle is from the collection, the processing, the storage, the transmission, and deletion of the information. So we have to understand the entire data life cycle for the data subject and be able to track that information for the data subject right throughout the system, because the right of the data subject is to ask, what information do you have on me? And if you are not doing following this cycle, then you may not be able to tag data and be able to respond to those queries. The next thing is the information security practices, and information security comes into this. And a lot of persons, when we start talking about data and the Data Protection Act, there's this thing that persons sometimes confuse the two, privacy and protection. There are some overlaps as we talk about privacy and protection. And the overlap with privacy, security, privacy and protection, the relationship between them. Security deals with confidentiality, ensuring that only who needs to have the information can have it or access it at the time. It deals with integrity, that says the data is accurate. And we spoke about the right of the data subject to ensure that the data that we have is accurate. And then availability, to ensure that the systems hosting information is available. Then the privacy, where we're talking about, again, the collection, the processing, the storage, the transmission, and the deletion of the data. And in between those, you have the whole business of access and maintenance. Those two overlap to form, to have protection aspects. So there are aspects of privacy that will lean on security for the protection aspect. Grace spoke about privacy by design. And again, I mentioned that before, ensuring that you are being proactive in your privacy approach, ensuring that you have the proper default settings, ensuring that you have end-to-end protection if you are going to be transmitting data, ensuring that you take your data subject in mind. You have respect for your data subject whenever you're coming up with a concept that is supposed to support them. Then you have the analyze and assess. You have to analyze the systems that you have, analyze the information that you have, analyze the processes. And that is done through various types of risk assessment, including privacy impact assessment and data protection impact assessments, right? So then we touch on sustaining, and this is where we monitor systems for compliance with policies and regulations. We look at our entire risk environment. We audit those systems to ensure alignment, and not just alignment with laws and regulations, but also alignment with our business strategy, what we have set out to achieve as an organization or even as an individual. What are we trying to achieve? And to ensure that the information is duly communicated. One of the big part of data, the data subject rights, is how does company plan to respond? Somebody walks into your organization and say, listen, I want to have all the information. I want to know all the information you have on me. Now, based on how you collect and store information, this may be in multiple systems, or it may be in a filing cabinet, as Grace mentioned, or it may be, or it may just be sitting on somebody's computer in a file or in an email, right? It is a very difficult thing to respond based on how we currently operate, which means that our thinking has to change. And that has to change from ensuring that we only collect information that we absolutely need. And that goes back to examining our processes and our systems. There's response to for requests for correction of information and to ensure that the data remains in integrity. And we have to have systems in place to handle those, right? From a legal perspective, we have to comply with the legal framework, and there's some accountability, and there is an oversight body as far as the data protection, the Information Commission, I think, is in terms of providing oversight and ensuring that you are complying. For some organizations, will require the services of a data protection officer who is going to do, among other things, have a responsibility to the information commissioner, which means that you cannot, even though you hire a data protection officer, you cannot fire a data protection officer for doing their job. And that job may include reporting the organization to the information commission. Incident handling and incident planning goes hand in hand, because if you don't plan for failures, things can happen, right? Data breaches could occur, but you have to plan for those before you can effectively respond. And so you have to have defined rules and responsibilities, and you have to have ways of detecting incidents before they become a problem. And then handling those incidents, the incident handling has to do with your whole response. It has to do with communication and notification to data subjects and to the oversight body. So, you know, some of these things come into play. Now, to manage that, what we definitely need to look at is the last part of that is for tools, and there's a quest for tools. Now, tools are not a magic bullet where you're going to just go out and say, hey, give me some tools to do this, or give me some tools to protect me from that. It has to be done in a business context, and this is why I've laid this out in such a way, because you don't get to tools until you actually understand what you have. And some of the tools that you will have, you know, companies will say, I want to, excuse me, 1 second. Yeah, sorry. So apologies for that. So there is, you know, persons will say, I want to know what data is leaving my organization. I want to prevent the data from leaving the organization, especially in this work from home scenario. This is a situation where persons who are not in the organization, they're working from home or working from other places, working remotely. They have access to your data, but you have no way of knowing, you know, what data they may be copying off or storing otherwise. You have data security, which I mentioned before. Identity and access management is going to be crucial, because now only persons that need to see certain type of information must see it. And you know, if these controls are put in place, then it will minimize things like lottery scamming and all of that, because person won't get bulk of data to be interacting with to commit these felonies. Auditing and assessment tools are going to be important in coming up with coming up with the totality of your data privacy program. And discovery, inventory, and classification. Grace mentions sensitive data to deal with, you know, your political affiliation, sexual orientation, and all of that. Now, you have to have tools that are going to be able to go out and discover what you have in your infrastructure, then to inventory those and then classify. This doesn't have to be one tool in a tool set, but it would help, right? And then you classify by a different classification scheme. What is internal? What is sensitive personal information? What is personal information? What is derived personal information? We spoke about triangulation, and triangulation is really you know, being able to identify a data subject by putting different bits and pieces of information together. So it may be okay, this person is in their mid-30s and they work in the Hertfordshire area. They drive this kind of a car. They are in the information security business. You know, putting those pieces of information together may go a far way in identifying the data subject. Again, where we're seeing a lot of persons struggling from time to time is along these two last ones, the discovery and classification. By the way, classification is something that you should have been doing in your organization, because if you don't know what you have and what protection needs to go in place, then you won't know what tools or controls you're going to put in place to adequately protect that. So some of us are going to be buying a Rolls Royce to do the job of a donkey cart, or a donkey cart to do the job of a Rolls Royce. So we have to ensure that we understand that consent and request management is going to be crucial, because now it is not simply saying by default you opt in by default. It is now, I think, in some legislations, it is a situation of ensuring that you explicitly opt in and then have the option to opt out. All right. So that's really my spiel. We spoke about the whole data protection by default, and data protection by default is from collection, the processing, the storage, the transmission, and the deletion. Again, to reiterate, having a good security system in place helps. Having a good security program in place helps. But it doesn't mean that you have addressed the privacy concerns. So you still need a privacy program. It's not good enough to just have a security policy and have some security tools and think that you're doing privacy or protection as it is. You have to look at where they support each other, because they will lie in different sections of the business. Grace mentioned HR, and most organizations, when they're looking at data subjects, they usually forget to look at their critical data subjects, which are the people who are employed to them. Don't make that mistakes. This is about Symptai and why we are qualified to talk about these things. So right now I'll hand you over back to Andre. Thanks a lot, everyone.
No, thank you, Andrew. Very informative and a lot of information there to condense. So, and I wish we had a little bit more time, because I suspect and again, participants, feel free to submit your questions in the chat section or the question and answer section. So let's just jump right into that, and I want to pick up on a point that you left off on. We're seeing that organizations now have to implement a lot of things just to ensure compliance, right? So Grace talked about the rights of the data subjects. Now we're talking about the responsibility that organizations have to ensure that these rights are protected. So would you say that the rise or the increase in data protection and data privacy legislation is an accelerator for digital transformation? Andrew, can you speak to that a little bit?
Yeah, we talk about accelerator for digital transformation, but we're going to shift a little bit. The accelerator for the greatest accelerator for digital transformation that I've seen is this pandemic. All right, so I won't even go the data route. Is this pandemic? You have companies who have made plans, elaborate plans, 5-year plans to see how they're going to transform their business, and they even when they bring that to their stakeholders, the stakeholders are saying, "Boy, this is not possible to do in this time because we have this and that to do." Then COVID happens, and this thing that was supposed to take 3 to 5 years, now companies had to pivot to make sure that this occurred in 2 months, right? They had no choice. But they also had to do that with considering the other challenges, the challenges of data protection, right? The challenges of security. So some companies like, okay, cool, we need to send people home to work from home without even doing a risk analysis. Does the person have adequate working space? Do they understand the responsibility that they have when they're now accessing the company's data remotely? Can they still give their laptop to their child to play on? Now that they're using it for critical work and handling sensitive and personal data for individuals. It is an it will be an important piece of the digital transformation, but I will tell you that the greatest accelerator right now is this pandemic. Grace?
I am 100% in agreement with you, Andrew. You're seeing more people looking for policies, bring your own device policies, or even work from home policies in respect of cybersecurity, data security. It really has accelerated, and this is from the technology side, it has accelerated interest in more products. For us as persons who are in the compliance sector, who are in the legal side, it has made us pressured in terms of policies. People want, more succinct policies in respect of devices at home. So people are looking at that more so privacy policies and taking a different look at privacy policies as well. So yes, COVID is a game changer, I think. I think it was the head of Microsoft that said that it has accelerated us maybe 10 years or more in terms of where technology could have taken us, right? Or where technology uptake took us, because I think the technology is there, but now people are recognizing the importance of using what's available.
Good, thank you. Another pressing question is really, where does the responsibility of or for data privacy sit within an organization? So based on the conversation that we've heard from both yourself, Grace, and Andrew, some people can walk away thinking, well, it is an IT responsibility, or it is legal's responsibility, or it's compliance, or it's senior management. And it's almost as though nobody really wants to take ownership of the program. So the question is, where does the data privacy program sit within the organization?
Okay, very excellent question. And I believe we had a seminar last year in which this was fully fleshed out as to, whether it should lie in tech or should lie in compliance or legal. It's really a mixture of all. And I'm going to lean on what the Act says, because you have to be in compliance with the law. Now, various organizations will be required to have a data protection officer. Large organizations that will deal with large data sets, rather, public authorities, and a few other specific types of organizations. The data protection officer does not have to be in-house, it can be an organization, but you need to have a point person for that compliance department or external contractor who will be doing your compliance. So you're going to have somebody who knows a bit about tech, but it's good at compliance, it's good at recording, it's good at following up and really project management on a whole different area, on a whole new area. But it doesn't stop at that level, because directors can also be held accountable. In fact, persons who write directors of companies who have responsibility, who seemingly have responsibility, can be held liable and can be fined under the Data Protection Act. I found that surprising. In this scope, something that we have, for instance, in our income tax legislation, but for something like data, I found that surprising. So it's at every level, it's at the board level. So what it means is that if you're a board director, even an independent, non-executive board member, you need to start asking the question at board meetings: what's happening to data security? What's happening to the work from home? Know that your company has now moved to this pandemic-related work from home situation. Everybody in the organization needs to take responsibility at different levels, rather.
Thank you. Andrew, any thoughts?
Yeah, I mean, it is a question that we get asked quite a bit. Where does it sit? And as Grace mentioned, that if you have a data protection officer, then they have to be aware and be proficient in several different areas. And that will determine, it's more looking at the individual who fits the bill rather than where they sit in the organization or where it should sit in the organization. From the perspective of fines, individuals can be fined, and even if you are a director that, to add to what Grace said, that has instructed someone else to carry out a task that is in contravention of the law, then you could be held liable for prison term or fines, according to the Data Protection Act. But yeah.
Right. Okay. One of the things that you talked about, Grace, is the right of the data subject to request access to the information that's being held on him or her. Does the information have to be presented in a particular format, for example? So if you're blind, does it have to be in Braille if you are hearing impaired? So does the law make any kind of specific recommendations for how the data is presented when requested?
Excellent question. The law does make provision for that. It does require it to be in a readable format. You have raised a very good question about whether the person is, visually impaired. And that's something which, by our Disabilities Act, when it comes into force, will perhaps have an impact on all pieces of legislation, including this one, in terms of the preparation and issuance of documents. But yes, you have to make sure it is in a readable format, and there is a requirement for it to be in a what we call a portable format. So when you require a document and you want to move your information, rather, from one individual or one company to another company in the same sector, it should be in a manner which can be easily accepted by that recipient. And that's something that the Data Protection Act does speak to. What I have been asking companies within particular sectors, for instance, insurance sector, or sectors in which there's going to be some mobility of data, is that they come up within their organization's rules on data portability, whether it's an Excel format or any other format for data storage. And this doesn't mean that you're going to be sharing technology per se, but certainly in terms of the method through which you download the data, that you come up with rules of portability and uniformity, because they will be in breach if it cannot be accepted by another entity. And so that's an increasing area for trade associations to look into.
Okay, got it. A couple of questions coming in, and we just have a little bit under 3 minutes to go. So I want to get to some of these before. Does Symptai offer, this is from Stacey Hines, does Symptai offer info sessions concerning what companies should be doing to navigate the data protection requirements directly to organizations? Andrew, do you want to take this one? You're on mute, Andrew.
Yeah, I think Andre, I think you're in the best position to take that question.
The simple answer to your question, Stacey, is yes. Symptai has been doing a lot of work in this space for the last 2 years, starting with the GDPR and now with the Jamaican Data Protection Act. So we do offer specific information sessions to companies as well as consulting services to help build out a data privacy program to help to be in compliance with
yeah, and from that, I mean, and from sessions, we also, and I know Grace does a lot of this also, we also engage with the senior management and executive management and board of directors in terms of bringing them, making them aware of some of their roles and responsibility as it relates to that. So that's a session that, you know, would be more than willing to present to any board of directors or any staff, really. And that's something that I'd gladly work with Grace, considering I'm not legal, I'm not a lawyer, and can interpret those legislation as well as Grace does it. You know, certainly it would be something I'd be more than willing to partner with Grace to do.
Great. All right, two other questions. One is, are all, one for everyone, one for Grace, I imagine. So this one for you, Grace. Are all organizations required to have a data officer?
Right. So not all organizations are required to have a data protection officer. Let's start with the ones that are required to or will be required to have one. Public authorities, organizations that process sensitive data, which when you think about it and the categories, as I said earlier, there are lots of categories. So you have to really, look at the definition of sensitive data. Organizations which manage a large scale, which what the Act says, a large scale of personal data. I am a little bit confused as to what that means. I'll wait on the regulations to perhaps define what large scale data means, and any other organization what the government may prescribe specifically indicate in law. You don't fall within those 3 categories, but I need you to have a data protection officer. In terms of exempt organizations, NGOs are exempt, or rather, let me say, not NGOs, but yes, not-for-profit organizations dealing with political, philosophical, religious, or trade union purposes. So those organizations are going to be exempt, and also organizations that deal with public registers. So I think the National Library, organizations like that are going to be exempt from having or requiring a data protection officer. The big one here, big ticket item is, do you handle large scale data sets or do you handle sensitive data, right? So you need to make a decision, and you need to do the sort of inventory and classification that Andrew spoke about to determine whether you fall within any of these categories. And then you get a data protection based on what your evidence reveals or your research reveals.
Yeah, Grace, I have a quick one for you. Will this legislation be retroactive?
No, I do not think it's retroactive, and we generally don't pass legislation that's retroactive. So it's, so no, going forward, no. It's something for the future, and of course,
yeah,
a time frame for implementation.
Yeah. And the reason why I ask this is because if somebody suffers a data breach today and that legislation is in, can someone make a claim against them when the legislation comes in force 2 years' time? Which is why I asked.
No, you can't. But remember what I said earlier about NIDS now giving us a clear path to informational privacy. And I've been very circumspect in saying this to companies, that because persons don't have a right to informational privacy, and coupled with that is Jamaicans can what we have horizontal claims against private individuals. You as a private individual can sue me if I breached your constitutional right. And that constitutional right now includes the right to privacy. In other words, you are liable or could be held liable if there is a data breach under constitutional provisions. A bit far-fetched, but it is a possibility as of now, even while we don't have the act signed.
Thank you. All right, we're out of time, but there is one question. Andrew, I don't know if you can answer this in 30 seconds. It's from Dr. Patricia Holness. What protection can be provided to users when they participate in Zoom meetings? You're on mute, Andrew.
Yeah, right. Zoom meetings. A couple of things you do when you do Zoom meetings. We have this tendency to use our personal Zoom page, and we send out the ID with that with the passwords. And what happens in that case is that once you send that out once, persons will always have access to your Zoom, so they can jump in. Zoom recently has put in a lot of other controls. You know, things like, you know, not allowing you to set a password separately from the URL. Some of us we send out the URL and it has the password and everything else. What you can do is to prevent not to send out the entire URL, but to send a username and password on a separate cover, or a password for the link on a separate cover. Zoom also has the admit feature where you can prevent persons from joining or to kick persons out of your session. So if you can't recognize the person, then they can't Zoom bomb you. Now, Zoom came under a lot of fire earlier this year because of the fast growth in persons looking for remote collaboration tools. And they came under a lot of fire. And I was saying from then that this will only make Zoom stronger, and stronger it did make them. They responded to a lot of the threats. There's still some out there. Security threats are still great, you know, out there, but it happens every other day. A new problem can come up, but they have been very responsive. Now, and other software vendors have taken, you know, taken some of the lessons learned from some of the Zoom problems and have also made their framework stronger, like Microsoft Teams and Cisco, the WebEx platforms. So the platforms are getting much more stronger as we speak, and they have mechanisms. So just check out the privacy mechanisms for those.
Great. Thank you so much, Andrew. Thanks a lot. Thank you, everyone, for joining us. We've come to the end of our webinar. I need to also inform you that we're going to be having a training, Certified Information Privacy Manager training that is being offered through the IAPP, International Association of Privacy Professionals. That starts on the 7th of September. More information is going to be on our social pages, LinkedIn, Instagram, and on Twitter. Thank you very much, Grace. Thank you very much, Andrew. This has been a really informative conversation. I suspected, well, we're going to need some more time next time. You know, perhaps we can do a part 2 because there are so many other things that we needed to talk about. But thank you very much to everyone too for joining. I hope you found it as informative as I did. Have a good day, everyone.
Thanks, everyone. Have a good one. Bye-bye.